Hi, this is Doug Bradley, owner of InlandEmpireLawyers.com, and I'm here today with attorney Stephen Levine, who practices family law, personal injury, and is also a California State Bar certified criminal defense specialist. Practices out of Redlands, California. Stephen, thanks for joining me today. I appreciate you taking the time to chat.
Thanks, Doug.
Yeah. Really,
Good to see
today
you.
I just really wanted to talk with you a bit about your practice overall, but I'd like to get started with how you got interested in going into law.
Well, I grew up in the 60s, and it was a time when a lot of people were doing a lot of demonstrating and were in opposition to various things, and people were wearing long hair, and the Vietnam War was going on, and um, I was fortunate enough to go off to college and become educated, but a lot of people I grew up with didn't have the opportunity to go to college. And when they got in trouble with the law back then, you had the option of going to jail or going to Vietnam. So there, but for the grace of God, went I. So that was a kind of an impetus for me to study law. And I've always been interested in criminal defense. And I segued into criminal defense right out of law school.
Hmm. Uh, yeah, that's just kind of curious why you chose criminal defense. I know you're a state bar certified criminal defense specialist. Can you tell me a little bit about what that means and why you chose to get the specialty in criminal law?
Sure. My first 11 years of practice, I've been practicing since 1977. My first 11 years of practice were with the San Bernardino County Public Defender's Office. I went out into private practice in 1988, and several years later, I took the State Bar Specialty Exam. To become a certified specialist in criminal defense, you have to take a day-long examination. It's similar to another bar exam. And I, for the life of me, don't know that day why I was sitting there taking another bar exam, but I did it. And you also have to get the recommendations of judges, district attorneys, fellow attorneys, show them work product, show them a history of your trials. At that point in time, had probably over 150, 200 trials to my experience based off the public defender's office and my first few years in private practice. And I have been a certified specialist ever since.
Yeah, so
Basically, that it tells the consumer that there's a certain amount of expertise. It also tells them that I'm a little long in the tooth.
yeah,
In other
and
words, I'm old.
yeah. Well, I don't know that I'd say you're old, but you know, definitely
Older.
experience in law counts, right? And
Right.
the criminal, the certification for the criminal defense basically goes to show the complexity of how you get it. It's not like checking a box. It's not like just filling out an
Right.
application and getting approved.
No, it's a very complicated process, and I have to continually upgrade it. I can't remember if it's every 3 years or every 5 years. I have to show them that I have continued to do trials, continue to get continuing education at the bar, and provide to them proof that I will continue to be considered as a certified specialist.
Sure, sure. No,
So it's an ongoing process.
yeah, yeah, absolutely, absolutely. So you also practice personal injury and family law. How does all of this work together?
Well, our firm practices personal injury. I personally don't practice
Okay.
personal injury, but our firm does handle personal injury matters. We have three or four very experienced attorneys that do. I concentrate primarily on criminal defense and family law. So you can kill them or divorce them, I can take care of you. Um, when I went out into private practice, I shared office space with a very experienced family law attorney who was a certified specialist in family law. He was so busy that he began to have a buildup in time between making an appointment and being seen by his clients. I started to take some of his uh, spillover, people who didn't want to wait too long to see him. And I studied with him and was mentored by him in family law. So I've been practicing family law again. I'm showing my age, but I've been practicing family law since 1989, and I like to think that I've become fairly experienced in that field as well.
I imagine there's a fair amount of carryover from one practice to the next. If you're working with somebody on family law matters, oftentimes they'll become your attorney, you'll become their attorney for, if a family member is accused of a crime or arrested for something.
Yeah, absolutely. There is a lot of relation back, or other family members or relatives will give our name. That is our best advertising is word of mouth. People who are satisfied with our product will tell other people. And that personal referral is the best satisfaction I have. People appreciated the work I put in on their cases. There is a lot of commonality between the two. Take domestic violence. In the family law section, we would have the domestic violence restraining order, and we also would have the related criminal charge in the criminal department if the person was charged by the district attorney's office. So I can handle both matters at the same time. That does save the client some money.
Sure. I would imagine that it would. Kind of talking about criminal defense, what would you say is your most common case? Would you say it's DUI or drug possession? What in that realm is your most common type of case?
I would say DUI, domestic violence, and drug possession are our most common cases.
Okay. And in the world of DUI, I always see in when I'm working with an attorney on their marketing, and I always see the statement, you only have 10 days to save your license. I imagine a lot of people have a question about that immediately because they don't want to lose their license so that they can't go to work or drive around or pick up kids or whatever. Tell me about the specifics of what that 10-day clause in the law is.
Sure. You're talking about the administrative per se law. And this has nothing to do with the court itself. This is administrative with the Department of Motor Vehicles for the state of California. They have implemented a law that basically says, regardless of what goes on in court, when you were arrested for a DUI, the Department of Motor Vehicles is going to take action against your privilege to drive within the state of California. You only have 10 days from the date of your arrest to request such a hearing. When a person is released from custody or cited for the DUI, the arresting officer normally will provide them a double-sided pink piece of paper that has all kinds of small print on it. And normally, this is the only time that your average citizen comes into contact with the law is on a DUI. This is a middle-class crime. It affects a lot of people. And a lot of people will not read that advisal that's on that little piece of pink paper until maybe 2 weeks later, and they won't schedule an appointment with an attorney in 2 or 3 weeks later. And by the time they come to see the attorney basically the hands are tied because the Department of Motor Vehicles is very tight about that 10-day limit on requesting a hearing. You're requesting a hearing to prevent the Department of Motor Vehicles from taking action against your driver's license and suspending your privilege to drive in the state of California, regardless of what happens in the criminal matter. This is separate and independent of the criminal matter.
Okay.
So it's very important that people read that piece of pink paper. It's very important that they seek legal counsel right away. And it's very important that they protect their rights by requesting that hearing within the 10 days.
Okay, so a couple of follow-up questions to that. What's the amount of runway that a person needs in order to contact you? So if I contact you on day 9 of that 10-day period, can you still be effective? And then also the follow-up to that is, what happens if I exceed that 10 days? What's the consequence of that?
First of all, if you're calling me on day 9 and you're seeking an appointment, we'll try to squeeze you in on day 9 because we'll explain to you you've only got a day to request a hearing.
Right. Okay.
But what this office does that some other people don't is we don't try to scare you. We will provide you free advice that go ahead and schedule that hearing on your own. Call the DMV within 10 days, even if you haven't seen the attorney yet.
Mm-hmm.
Call the DMV and request a hearing. The attorney can always try to reschedule the hearing that you have set yourself with the DMV. You blow the statute if you don't call.
Okay.
So we want you to call regardless of whether you've retained us, retained somebody else, haven't decided on retaining an attorney yet or not. We don't want you to lose your driving privilege. So we always emphasize to call the DMV regardless of whether you're hiring us.
Gotcha. Okay.
The impact, if they blow the 10-day statute, on a first offense, your driver's license privilege is going to be suspended for 4 months administratively. On a second offense, your driver's privilege is going to be suspended for a year administratively.
Mm-hmm.
The same for future and subsequent DUIs.
Okay.
On first offense, you would have the right after 30 days of that suspension to request a restricted driver's license. You would have to provide proof that you've enrolled in the first offender alcohol program, proof of insurance, and pay a reissue fee to the Department of Motor Vehicles. If you show them all that, then they would provide you with a restricted license to allow you to drive to and from the alcohol program and to and from and within the course of your employment. That is not available to you on a second or subsequent offense, only on the first offense.
Okay. And knowing that DUI is one of the more common charges that you handle on a day in day out basis, what are some of the more complex legal issues that you handle, whether it be in the realm of criminal defense or family law?
Well, in the criminal defense, I've handled everything from traffic tickets to death penalty cases. Obviously, a death penalty case is very complex and takes a lot out of you personally.
Sure, I imagine.
White-collar crimes are very complex. Real estate fraud, Medi-Cal, dental-cal fraud. I've handled all of those. They are voluminous in paperwork, and thus they are very complicated because you have tens of thousands of pages to sort through to become prepared and become knowledgeable enough to present an adequate defense to your client. So they're very complicated matters. Other homicides can be complicated. Sex offenses can be complicated and can be very difficult for society to accept the defendant or the defense attorney in defending against those. But they can be complicated in they require a certain approach in questioning victims and a certain approach in approaching the district attorney's office, all of which we provide. From a family point of view, I would say some of the more complex things are when we have large productive businesses owned by the community that are going to need some type of forensic accounting to divide. Again, paperwork becomes voluminous and evaluation becomes a difficult process. Some of the more difficult family law matters for my clients always involve the children, because there's so much emotion involved that it is always difficult for them. And as much as I love to counsel them, I'm not a therapist. I am an attorney, and I will direct my clients from time to time to seek additional counseling to deal with the problems of separation from their children or things like that from an outside source. I'm there to help as well, but I'm there for court. I'm there for the legal matters. And those can be very difficult, though, and trying and emotional for my clients.
Sure. Yeah, I would imagine that anytime children are involved in anything, whether it be on the criminal defense side or on the family side, that's probably some of the harder cases to handle.
Absolutely.
Yeah, and getting back to what you were saying about the family law aspect, the what I heard you say is the more complex cases like a high asset divorce of if the family owns a business that has a large amount of revenue and then trying to untangle that between the two parties. Is that what I understood to be correct?
That's correct. The dissolution, the division of that
Sure.
that asset, or the trade-off of that asset can become very complex.
Okay.
Subject of a lot of litigation.
Now, if somebody calls to make an appointment and they need a consultation and some initial advice, will they be talking to you directly, or what's the process there?
No, when they call the office, they'll be talking to one of our legal assistants, and they're very pleasant. They're there to schedule the appointment as soon as possible, because we know delay is frustrating to the prospective client, and also the emergency is now, and we
Sure.
try to cater to that and try to schedule as soon as possible.
Excellent. Well, thank you so much again for your time, Stephen. I really appreciate it. If you need more information about Stephen and his practice, he's with Milligan, Beswick, Levine, and Knox in Redlands, California. You can go to his website, mblklawfirm.com. That's mblklawfirm.com, or you can call 909-798-3300. And the links and the information regarding Stephen's practice will be in the description of this video. Thank you again for your time, Stephen. You have a great day.
Thanks, Doug. Thanks, everyone.
Bye-bye.
Bye.